Mr. President.
Senator from Tennessee is recognized.
Mr. President, I'd like unanimous consent to send a
We are in a quorum call.
I'd like to ask unanimous consent for the quorum call to be vitiated.
Without objection, the senator from Tennessee is recognized.
Thank you, Mr. President. And also like to ask unanimous consent that a modification to Amendment 1172 be accepted.
Is there objection? Without objection.
Mr. President, I'd like to talk briefly about this amendment. I think most people in this body understand that we are reimbursing the Pakistan military for efforts that they are putting forth on behalf of what we're doing in Afghanistan, enduring freedom. And we have crafted an amendment that asks for certain reporting to take place from the Pentagon and for them to look at ways of diminishing this reimbursement over time as we wind down our operations in Afghanistan. This amendment has been drafted in such a way as to not to further escalate tensions between us and the government of Pakistan. This is a good government type of amendment that just asks the Pentagon to begin looking at ways of decreasing the support that we're giving to the Pakistan military on our behalf regarding Afghanistan as we wind down our operations there simultaneously. It's my understanding that both the majority and minority leaders of the Armed Services Committee have accepted this, and there's no hold from the majority on the Foreign Relations Committee, and I hope that we'll have an opportunity to vote and pass this by voice vote very soon. With that, Mr. President, without further comments, go ahead.
Senator from Arizona is recognized.
Mr. President, I support the amendment as modified by the senator from Tennessee, Senator Corker, who has devoted a great deal of time and effort and thought into this issue, and the result is this amendment. And I would point out that it would require the Secretary of Defense to prepare a report on the effectiveness of coalition support fund reimbursements made to Pakistan in support of coalition military operations in Afghanistan. Before I proceed, let me once again express my deep condolences to the families of the Pakistani soldiers who were killed this weekend in a cross-border air action. All Americans are deeply saddened by this tragedy, and I fully support NATO and U.S. military in their commitment to conduct a thorough and expeditious investigation. As my colleagues will recall, and this is the important aspect of Senator Corker's amendment, Congress has authorized and appropriated funding for coalition support fund reimbursements to Pakistan since we began our military operations in Afghanistan. At the time, Pakistan made a strategic decision to support the U.S. war effort against the Taliban government in Afghanistan and their al-Qaeda terrorist allies. In response, Congress and the Bush administration agreed to reimburse the Pakistani government for military activities that support our mission in Afghanistan. Over the past decade, Congress has provided billions of dollars worth of these reimbursements to Pakistan, and we should acknowledge that much good has come of it. Over the past few years in particular, Pakistan has shifted tens of thousands of their soldiers from the eastern border of their country opposite India to the tribal areas in western Pakistan. Pakistani troops have been deployed and engaged in military operations in their western provinces and tribal areas for more than 2 years straight. And they paid a heavy price in this prolonged fighting. Hundreds of Pakistani troops have given their lives to fight our mutual terrorist enemies in their country, and thousands of Pakistani civilians have been tragically murdered in the same time by these militant groups who show no compunction about attacking weddings and funerals and mosques. We honor the sacrifice of Pakistan soldiers, and we mourn the loss of innocent Pakistani civilians. It must be noted, however, that certain deeply troubling realities exist within Pakistan. It must be noted that elements in Pakistan's army and intelligence service continue to support the Haqqani network and other terrorist groups that are killing U.S. troops in Afghanistan, as well as innocent civilians in Afghanistan, India, and Pakistan. It must also be noted that the vast majority of the materials for improvised explosive devices that are maiming and killing U.S. troops in Afghanistan originate within Pakistan. These are facts. We cannot deny them, and any effective strategy for Pakistan and Afghanistan must proceed from this realistic basis. It is for this reason that I believe this amendment and this report would be extremely useful. Already in response to recent Pakistani activities, the administration has chosen to withhold Coalition Support Fund reimbursements to Pakistan. Over the past 2 quarters, that withheld money amounts to roughly $600 million. And I can imagine that amid the current tensions, further administration requests to Congress for reimbursement of coalition support funds for Pakistan will not be forthcoming. The report requested in this amendment would seek additional information on the amounts, types, and effectiveness of coalition support fund reimbursements to the government of Pakistan. It also would seek recommendations as to the future disposition of this program, including potential alternatives to it or the possible termination of it altogether. That option cannot be ruled out. This is valuable information and recommendations to have as Congress continues to discuss and debate not just the future of the Coalition Support Fund reimbursements to Pakistan, but the future of our relationship with Pakistan more broadly, and I strongly support this amendment. And again, Mr. President, I don't want to spend too much time stating the facts. And this is a terrible dilemma. Fact is that Pakistan is a nuclear nation. They have a significant nuclear inventory. The fact is that for 10 years, we in Pakistan had virtually no relations. We found that not to be a productive exercise. But at the same time, when there exists, as my colleague from Tennessee will agree, 2 fertilizer factories from which come the majority of materials from which a majority of IEDs are manufactured and killing young Americans, it's not tolerable. I understand, as I said earlier in my comments, the tragedy that resulted from the deaths of these young Pakistani soldiers. I also understand, as every one of us do, what it's like to call a family member of a young man or woman who has lost their lives in Afghanistan, many times as a result of an IED. In a hearing in the Committee on the Armed Services Committee, then Chairman of the Joint Chiefs of Staff, Admiral Mike Mullen, stated, and I quote, "The fact remains that the Quetta-Shura and the Haqqani network operate from Pakistan with impunity." I want to repeat, these are the words of the former Chairman of the Joint Chiefs of Staff. "Extremist organizations serving as proxies of the government of Pakistan are attacking Afghan troops and civilians as well as U.S. soldiers. For example, we believe the Haqqani network, which has long enjoyed the support and protection of the Pakistani government and is in many ways a strategic arm of Pakistan's Inter-Service Intelligence Agency, is responsible for the September 13th attacks against the U.S. Embassy in Kabul." He goes on to say, quote, "There is ample evidence confirming that the Haqqanis were behind the June 28th attack against the Intercontinental Hotel in Kabul and the September 10th truck bomb attack that killed 5 Afghans and injured another 96 individuals, 77 of whom were U.S. soldiers." And finally, another comment by Admiral Mullen, who, by the way, who had worked very, very hard for a long period of time to develop a close working relationship with General Kiani and other military leaders in Pakistan. He went on to say, quote, "The Quetta-Shura and the Haqqani network are hampering efforts to improve security in Afghanistan, spoiling possibilities for broader reconciliation and frustrating U.S.-Pakistan relations. The actions by the Pakistani government to support them actively and passively represents a growing problem that is undermining U.S. interests and may violate international norms, potentially warranting sanction. In supporting these groups, the government of Pakistan, particularly the Pakistani Army, continues to jeopardize Pakistan's opportunity to be a respected and prosperous nation with genuine regional and international influence. Now, finally, I'd like to say again, this is an incredibly difficult challenge for United States security policy. We have a country on which we are dependent in many respects for supplies, for cooperation, for hopefully not to be a sanctuary, although it's not the case, for Taliban and al-Qaeda elements. We have a country that is a nuclear power, and we have a country that has a government that I will say charitably is very weak. So, it seems to me that the Corker Amendment is important for the American people to know exactly where we are, what policy we're going to formulate, and what measures need to be taken, because we have, as I mentioned earlier, spent billions of U.S. taxpayers' dollars. Now, that doesn't play very well in states like mine, where we have 9% unemployment and more than half the home, or just less than half the homes underwater. So the Corker Amendment isn't all we need. In fact, we need to have a national debate and discussion about the whole issue of our relations with Pakistan. But I believe that the Corker Amendment is a very important measure so that we can assure the American people that not only are their tax dollars wisely spent, but that actions are being taken to prevent the needless wounding and death of our brave young men and women who are serving in the military. Mr. President, I yield the floor.
Thank you.
Senator from Michigan.
Mr. President, I support the amendment of the senator from Tennessee. It's a balanced amendment which deals with a very complex situation. What Senator Corker is doing is pointing out some very important facts, and that is that Pakistan has received a lot of funds from the United States for this particular purpose, which is aimed at helping the success of our operations in Afghanistan. The whole purpose of the Coalition Support Fund is to reimburse Pakistan for the support that they provide, for instance, in providing security for trucks and other equipment that is going through Pakistan that have oil or fuel and food going into Afghanistan to support the effort in Afghanistan. That's the purpose of these funds. And it's a good purpose, and this is not a foreign aid deal. This is a reimbursement deal. The problem is that while on the one hand the Pakistanis are assisting us, on the other hand they're assisting our enemy, and the enemy of mankind, and the enemy of the Afghan people, and the enemy of the coalition forces in Afghanistan. And that's the problem. That's the dilemma which we all face and which this amendment seeks to address. And again, it does so in a way which doesn't prejudge the outcome of the assessment, but it makes a very important point, which is, as is now stated in the amended final paragraph, that we need recommendations. Given this, on the one hand, they're with us, on the other hand, they're against us situation, we need recommendations from the administration, if any, relating to potential alternatives to or termination of reimbursements from the Coalition Support Fund to the government of Pakistan, taking into account the transition plan for Afghanistan. I agree with my friend from Arizona that we send condolences to the families of troops in Pakistan who have recently lost their lives. And we also have to understand that Pakistan has paid a huge price for terrorism in their country. against their people. They paid a massive price. But what is unacceptable to us is that they are making us pay a price by providing a safe haven for the Haqqanis and for the Quetta Shura. They are making our troops, our families, coalition troops, coalition families, Afghan troops, Afghan families, are paying a heavy price because of the Pakistan support through their ISI for the insurgency in Afghanistan. Now, Admiral Mullen, the former chairman of the Joint Chiefs of Staff, put it very, very succinctly. He said that the Haqqani network is a veritable arm of the Pakistan Intelligence Service. And when he was pressed on that formulation, he said he meant every word of it. And so we've got to send an important message to Pakistan. And that message is we want a normal relationship if we can have one. But we can't have a normal relationship if you're, on the one hand, supporting the very people who are attacking us in Afghanistan, and on the other hand, purporting to help us through the protection of supplies going through Pakistan, helping us succeed in Afghanistan. We can't have it both ways. They can't have it both ways. And this amendment sends a very significant and important message, I believe, to the Pakistani and to our coalition allies and to our Afghan partners, that what's going on inside Pakistan has got to come to an end. And this will help, I believe, bring that important result about. And so I very much support the amendment of Senator Corker, the senator from Tennessee, and hope that we can adopt it. If there's no debate about it, there may be others that do want to debate. So I yield the floor.
Mr. President.
Tennessee.
Mr. President, because of the tremendous cooperation, Senator from Michigan, Senator from Arizona, obviously my goal is to cause this amendment to be passed, and didn't provide a lot of context because I know they both support this. But I want to thank them both for their comments. I don't think there are two senators that can better articulate the issue that we face in Afghanistan with Pakistan, who is both a friend and foe in many occasions. None of us, I think, that have traveled Afghanistan. I know these two senators have probably more than most, but none of us who've been there, all of us who've been there, have heard our generals talking about the fact that they're fighting a war in Afghanistan that's being really led and directed out of Pakistan. And so basically, you know, we have an issue here, and I think you all have articulated the issue very well. The fact is that we need to know, first of all, if what we're doing in support of the Pakistan military is effective for us. And y'all have outlined that's a big issue. Second piece is how we're actually reimbursing. If you talk with folks at the State Department, I mean, we literally are going through reams of invoices and documents, looking at how many bullets they've used, how much food has been supplied to the military, what's going to be counted, what's going to not be counted. We're spending more time in many ways accounting for this than we are really looking at how effective the aid is. This amendment would deal with both of those. I thank you for putting this in proper context, and I do hope with your support and the support of the Chairman of the Foreign Relations Committee, this is an amendment that we can voice vote. I thank you both for your leadership on this issue, but also for putting this in the appropriate context. Thank you very much, and I yield the floor.
Is there further debate on the amendment? Without objection, the amendment is agreed to, as modified.
Move to reconsider that vote. Move the lay on table.
Without objection.
Whoops. I thought that, the Senator, I believe that Senator Cantwell wanted to be recognized at this point. And I note the absence of a quorum.
The clerk called the roll of the Senate.
Mr. Cochran.
Senator from Washington.
I ask that the quorum call be dispensed with.
Without objection, the senator is recognized.
Mr. President, as we continue to make progress on the defense authorization bill, and hopefully somewhere here in the halls of Congress we're also making progress on the FAA authorization bill, and maybe before the end of the year getting that to a final resolve. I know my colleagues on both sides of the aisle are working very hard, but I just had to come down to the Senate floor at this moment to say that Christmas came early in the Northwest today when a major deal between the Boeing company and aerospace workers machinists resolved what had been a conflict in the past on how to work together. A new relationship of working together on incentives and efficiency and performance has resulted in the Boeing company making a decision to build the next generation 737 MAX plane in the Pacific Northwest. That is great news for aerospace workers in Puget Sound. It means that there are going to be a skill set of building fuel-efficient planes for many, many years to come. But it is a great testament to both the company and the workers who, a year ago, you probably heard more about the NLRB issue, and now what you're hearing about is an agreement on a multi-year contract that is going to get these workers jobs in building planes on the next generation technology. This is very, very big and important news, not just for the Pacific Northwest, but for the country, because it means that we can come together to resolve differences. I would hope the United States Senate might apply some of the same things because the dispute at where these two organizations were about how to proceed to the future obviously had a lot of discussion even here on the Senate floor, and yet now today we see them coming together in a huge milestone agreement that means that more planes are going to be built in an agreement where workers and the company are working together to improve performance and deliver these planes that many, many people want because they are so fuel efficient on time. So for the Northwest to have this kind of boost shot in the arm at this point in time is really, really important. I expect that as this agreement and the agreement details are seen by many people, they'll see that this really is a way forward for the Northwest to continue to be at the top of the aerospace game. That's important because the United States needs to be at the top of the aerospace game. We're facing tough competition from many countries like China and Europe and others who are trying to lure a manufacturing base away from the United States. And what we see in the Northwest is not only do you have a company like Boeing, but you have a supply chain of many, many suppliers that are also working to make aerospace manufacturing in the United States one of the key industries that the United States is world premier in. So I just want to say congratulations to both the company and to the Machinists International for their hard work on inking this deal. I hope that it will bring much benefit and economic growth, not just to the Puget Sound, but certainly there, but to the rest of the country as well. I thank the President, and I yield the floor.
Mr. President.
Senator from Illinois.
Mr. President, I rise in support of the Feinstein Amendment with regard to Section 1031 of this legislation. I'm particularly worried because unlike the authorized use of force original doctrine and legislation passed by the Congress, we limited the authority of the President and the U.S. military to those connected directly to the September 11th mass murder of Americans. And I think in times of emergency, I understand that. But the legislation would be the first congressional authorization to go far beyond that, to say that any person who substantially supported al-Qaeda, the Taliban, or associated forces, undefined, including any person who committed a belligerent act, would be allowed to be picked up by U.S. military authorities and held in U.S. military detention. And while I am in favor of robust and flexible U.S. military action overseas, including action against American citizens waging war against the United States, like Anwar al-Awlaki, I think that we all should agree on a special zone of protection inside the jurisdiction of the United States on behalf of U.S. citizens. Now, I say this in support of the Feinstein Amendment because I took the time, as we all should from time to time serving in this body, to reread the Constitution of the United States yesterday. And the Constitution says quite clearly, in the trial of all crimes, no exception, there shall be a jury, and the trial shall be held in the state where said crimes to have been committed. Clearly, the Founding Fathers were talking about a civilian court of which the U.S. person is brought before in its jurisdiction. They talk about treason against the United States, including war in the United States. And the Constitution says it shall consist only in levying war against them or in adhering to their enemies, giving aid and comfort. The following sentence is instructive. No person, it says, shall be convicted of treason unless on the testimony of two witnesses the same overt act or in confession in open court. And I would say pretty clearly that open court is likely to be civilian court. Further, the Constitution goes on that when a person is charged with treason, a felony or other crime, that person shall be removed to the state having jurisdiction of the crime, once again contemplating civilian state court and not the United States military. As everyone knows, we amended the Constitution many times, and the Fourth Amendment of the Constitution is instructive here. It says the rights of the people to be secure in their persons, houses, papers, effects against unreasonable searches and seizures, including, by the way, the seizure of the person, shall not be violated, and no warrants shall issue except upon probable cause supported by oath or affirmation, particularly describing place to be searched and persons or things to be seized. Now, in Section 1031b2, I do not see the requirement for a civilian judge to issue a warrant. And so it appears that this legislation directly violates the Fourth Amendment of the Constitution with regard to those rights which are inalienable according to the Declaration of Independence and should be inviolate as your birthright as an American citizen. Recall the Fifth Amendment, which says no person, by the way, remember, no person, there's not an exception here, no person shall be held to answer for capital or otherwise infamous crime unless upon presentment and indictment, oh, hear the words, grand jury, except the cases arising of the land or naval forces or militia when in actual service in time of war, meaning that there is a separate jurisdiction for U.S. citizens who are in the uniformed service of the United States. But unless you are in the service of the United States, you are one of those no persons who shall be answerable for a capital or infamous crime except on indictment of a grand jury. The Sixth Amendment says that in all criminal prosecutions, not some, not by exception, in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. I go on to these because I regard all of these rights as inherent to U.S. citizens, granted to them by their birth in the United States. And if we go on through the Constitution and its amendments, we find in the 14th Amendment, it says that no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. Now, I realize that these powers have been defined by courts. But we would recall that even Abraham Lincoln, ex post facto, lost his ability to suspend the writ of habeas corpus pursuant to a Supreme Court decision. That we had in the case of Handy v. Rumsfeld, the court did recognize that under the 2001 statute, the President is authorized to detain persons captured while fighting U.S. forces in Afghanistan. But I will recall, and by the way, this included American citizens, I recall that was in Afghanistan. Clearly, we see in a case where an American citizen has gone to a foreign jurisdiction, joined a terrorist organization or foreign military, and is waging war on the United States, they could be held as a detainee of the U.S. military. Why didn't this legislation say that? Why didn't it restrict its purview to those provisions? In Padilla versus Hanna, the Fourth Circuit did allow the capture of a United States citizen Padilla, by the way, arrested at O'Hare Airport, a United States citizen, and held in military detention. And the Fourth Circuit said because he had foreign training and a foreign connection, that it was legal to hold him. But remember, very soon thereafter, the Bush administration surrendered this case. I think the Bush administration realized they were about to lose in the Supreme Court on the subject of whether the U.S. military could arrest and detain a United States citizen and to deprive them of their rights and subject them only to review under a petition of habeas corpus. I think they realized that they had to kick Padilla into the civilian court system, and therefore they did. And it's only in that context that we should read the Padilla decision. I think bottom line is this. We funded a multi-hundred billion dollar Department of Defense. In the words of the movie, to put men on that wall, that you need on that wall, to defend us against foreign threats, and that they must do hard and difficult things, including sometimes to United States citizens, like Anwar al-Awlaki, that are waging war upon the United States from a terrorist base in Yemen. But the whole purpose of this exercise and this institution is to defend the rights of the United States and U.S. citizens inside their own country. One of the first things you do when you join the U.S. military is not to swear allegiance to a president or to a foreign leader. You actually swear allegiance to the Constitution of the United States and to the rights that it has. What is the whole purpose of the Constitution? It is to defend your rights against the government, because we are one of those unique governments that posits a limited government in which rights are reserved, according to the 10th Amendment, to the states or to individuals, that your rights supersede the government. And so we cannot say for an individual, for example, in Wisconsin, who's never been abroad, who may or may not have committed an act, or may not have one association, that suddenly the United States military can roll in on that person, seize him or her, hold them in military detention, and only subject review of that case by one habeas corpus petition. I would argue then that all of your rights as an American citizen hang on the decision of the President of the United States. That if the President of the United States decides that you are substantially part of al-Qaeda, the Taliban, or associated forces engaged in hostilities against the United States, or you committed a belligerent act or supported such hostilities in aid of such forces, that all of your rights as an American citizen are now forfeit. Clearly, that's not the case. The Founding Fathers understood the power of the state run amok under a distant king that did not regard the rights of the individual as worth much. We founded a republic and then wrote a constitution to defend those rights. And while we face a very difficult and dangerous world overseas and have to do difficult and dangerous things, which I support, we should make sure that there is a place for peace and justice and rights inside the United States. And so for us, in looking at this provision, the Feinstein Amendment clearly limits the scope of this legislation in an appropriate way, that we do the difficult things overseas. But the whole purpose of the Department of Defense is to defend the United States and those rights inside our country. But that you, as a U.S. citizen, especially when you are inside this country, have inalienable rights which cannot be separated from you by any executive action. That you can only be held, incarcerated, that you can only have your liberties taken away from you on indictment of a grand jury, before a civilian court, and with a presumption beyond a reasonable doubt by unanimous vote of that jury. That is the essence of who you are as an American. And it is a historic decision that we would make here if we allowed this power to go forward. I think that's why Senator Paul and I were the only two Republicans to vote against it. It's why so many emails and letters that I received in the last few hours support this decision. And I understand that others have a different view. They describe the United States as a battlefield. And I would say that that is an overly harsh determination of how cheaply our rights can be held. that we have a multi-hundred-billion-dollar Department of Homeland Defense, that we have a substantial and capable FBI, that we have enormous state and city and local police establishments, all with the capability to investigate and prosecute crimes, but under the Constitution of the United States. And that if we hold U.S. citizens as capable of losing their rights on an executive branch decision, that it is that not beyond a shadow of a doubt, but on a lower standard of care, that in the executive branch's view, you are connected to one of these things, then your rights are not worth very much. I would say the whole purpose of the Constitution is to hold your rights higher than the government and subject only to review by a civilian court. And that review, as described in the Constitution of the United States, is far more than a habeas corpus review. The text of the Constitution specifically refers to grand jury indictment. For those who have questions on this, I would urge them first, take a moment to reread the Constitution. That first document which, as a member of the U.S. military or as an elected member of this body, you have to swear allegiance to, and then make up your mind. I think when you do, you will support the Feinstein Amendment, and I yield back.
Senator from Arizona.
Mr. President, I must admit that I have heard some bizarre arguments in my time as a member of this body, and referencing to the Constitution of the United States as a basis for the argument. Now, it's my understanding, my friend from South Carolina, I asked unanimous consent to enter to colloquy with the senator from South Carolina. It's my understanding
Without objection.
that under the Constitution, it's the Supreme Court of the United States who gives the interpretation of the Constitution as various laws and challenges to the Constitution, or is their responsibility. Is that a correct assumption?
Yes, it is.
So our colleague from Illinois, who continues to quote from the Constitution of the United States, fails to quote from the specific addressing of this issue by the United States Supreme Court, specifically the Hamdan decision. Is that correct?
That's correct.
Isn't it true that, according to that decision, the United States Supreme Court, that we asked to interpret the Constitution of the United States, and they have made many interpretations over the years, says, quote, "There is no bar to this nation's holding one of its own citizens as an enemy combatant." Now, one would think, to the casual observer, that that's exactly what the United States Supreme Court meant. It's fairly plain language, not really complicated. I'm not a lawyer. But how the senator from Illinois, quoting from inalienable rights, can somehow totally disregard in every way what the United States Supreme Court said. They go on to say, we held that, quote, "Citizens who associate themselves with the military arm of the enemy government," and I believe that in the view of most, would view that's a member of al-Qaeda, which this legislation specifically addressed. We hold that the citizens who associate themselves with the military arm of the enemy government and with its aid, guidance, and direction, which is exactly basically the language of our legislation, aid, guidance, and direction, enter this country bent on hostile acts, are enemy belligerents within the meaning of the law of war. How could anything be more clear to the senator from Illinois? I mean, it's beyond belief.
Well, the gentleman yields.
Beyond belief. Nor can we see any. Then they go on and talk about the Civil War. The United States Supreme Court does. They talk about the Civil War, and they talk about during the a code binding the Union Army during the Civil War that, quote, "captured rebels would be treated as prisoners of war." So, a citizen, no less than an alien, can be, quote, "part of or supporting forces hostile to the United States or coalition partners and engaged in an armed conflict against the United States." Now, after 9/11, we declared that we were at war with al-Qaeda. Is that correct?
Yes.
So we are at war.
Yes.
And we have American citizens who are enemy combatants, and yet the senator from Illinois, in the most bizarre fashion that I've heard, says that therefore they are guaranteed the protections of as he said, a trial. I don't get it. Maybe you can.
Well,
gentlemen, yield.
Explain. The senator from South Carolina, please go ahead.
Well, and I'll be glad to yield my friend from Illinois. Let me just try to set the stage the best I can, and I'd love to have Senator Levin weigh in and anyone else. The law, as it exists today, to my good friend from Illinois, is long held that when an American citizen collaborates with the enemy, that's an act of war, not a common crime. And the constitutional review provided by the Supreme Court in cases involving American citizens collaborating with the enemy has said that you view that as an act of war and you apply the law of war. So our Supreme Court in the Hamdi case just a few years ago upheld the ruling of the N. Ray Curran case, which went back to World War II. In that case, you had American citizens assisting Nazi saboteurs. And the Supreme Court ruled that your citizenship status does not prevent you from being treated as part of the enemy force when you choose to join the enemy. Why is this important? My good friend from Illinois is an intel officer. And intelligence gathering is part of war. An enemy combatant can be interrogated by our military and intelligence community without Miranda rights. They can be held for an indefinite period of time to be questioned about past, present, and future attacks. The Supreme Court has legitimized that process because the individual in question was an American citizen captured in Afghanistan, and he pled to the court, you can't hold me as an enemy combatant because I'm an American citizen. The court said no. There's a long history in this country of having American citizens who collaborate with the enemy to be held as an enemy combatant. Unfortunately, in every war we've engaged in, American citizens has provided aid and comfort to the enemy. In World War II, we had American citizens assisting Nazi saboteurs.
Wasn't one of the most famous cases a woman whose name was Tokyo Rose that propagandized? She was an American citizen, and she propagandized on behalf of the Japanese when we were in the war, and afterwards she was given a military trial.
Yeah. The point is...
Not a civilian trial, not given her Miranda rights, not...
Right.
Tried by military tribunal.
Right. Now, what we've done in the Military Commissions Act of 2009, civilians cannot be tried, American citizens cannot be tried in military commissions. They can only go to federal court. But the point that we're trying to make is it's been long held in this country that when an American citizen abroad or on the homeland decides to help the enemy, we have the right to hold you not under a criminal theory, but under the law of war, because your effort to help the enemy, to my good friend from Illinois, is an act of war against your fellow citizens. And this is so important. If we deny our country the ability to hold and interrogate an American citizen who's joined forces with al-Qaeda, we lose the ability to find out the intelligence they may have to keep us safe. If the choice is that an American citizen who chooses to collaborate with al-Qaeda must be put in the criminal justice system, then you will have criminalized the war, and the Congress will have restricted executive branch power. Make it clear, please understand to Senator Feinstein, that the courts of the United States have acknowledged that the executive branch can hold an American citizen as an enemy combatant when they engage and assist the enemy. The courts of the United States recognize the power of the executive as commander-in-chief to do that. The question for us, do we want to be the first Congress in the history of the nation to say to the executive branch, you no longer have that power given to you by the courts inherent within being commander-in-chief to protect us against enemies, foreign and domestic? I would argue to my colleagues, given the threats we face from homegrown terrorism, given the threats we face from al-Qaeda groups and their affiliates, Now is not the time to change the law, preventing our military and intelligence community from holding an American citizen who is helping the enemy on the homeland and prevent them from gathering intelligence. I would argue that the reason no other Congress has done this in past wars is because it didn't make a lot of sense. And I would argue that if you came to the floor of the United States Senate in World War II and suggested that an American citizen who has sided with the Nazis to sabotage American interest here at home cannot be held as an enemy combatant, you would have been run out of town, because most of your citizens would say anybody who helps the enemy, citizens or not, are a threat to our country. Unlike other wars, you do have due process that exists today that never existed before. No Nazi soldier was able to go to a federal court and say, "Judge, let me go." The reason that I've agreed and the courts have applied habeas review to enemy combatant determinations, this is a war without end. So how do you become an enemy combatant? The executive branch makes the accusation. They have to follow the statutory criteria. This is a limited group of people in a limited class of cases. American citizen or not, if you fall in this group, you can be held as an enemy combatant, but the executive branch has to prove to an independent judiciary that the case is sufficient, and under the law, the judge has to agree with the military. You have an independent judiciary looking over the shoulder of the military in this war unlike any other time. So the government has to prove to a federal judge by preponderance of the evidence that this person is in fact an enemy combatant. If the judge disagrees, they're let go. If the judge agrees, you hold these enemy combatants, and they get an annual review process as to whether or not future detention is warranted. So we have robust due process, but please understand what the Feinstein Amendment is about. It is about the Congress of the United States, the Senate of the United States, for the first time in American history, restricting the ability of the executive branch to hold an American citizen collaborating with the enemy and question them under the law of war. If we do that to ourselves, we will regret it. I don't want to be in the first Congress in the times in which we live to change the law, to deny our intelligence community and the Department of Defense to deal with American citizens who have decided on their own to become part of al-Qaeda. The day you decide, I'm going to side with al-Qaeda, you have committed an act of war against the rest of us, and the courts acknowledge you can be held for what you are, an enemy combatant, not a common criminal. The question for the Congress is, do we want to undo that in the times in which we live? I plead with everybody in this body, get yourself educated about what the law is today, and Senator Levin, we have done nothing to change the law in this bill. Is that correct?
Does 1031, which is the overall section, not change the law. It incorporates, according to the administration's own statement of policy, what the current law is.
Senator Levin, if
Senator,
I may.
I'm sorry, is exactly right. There's nothing in here which in any way affects habeas corpus.
Right. If the
nor could we, nor will we, nor do we seek to. Habeas corpus remains exactly as it is. We couldn't change it if we wanted to, and we don't want to. And I want to, while the senator has asked me a question, answer a question with a question to him.
Okay.
Is it not true that for the first time, the procedure we provide that where there is going to be an unprivileged enemy belligerent who's going to be held or could be held in long-term detention under the law of war, for the first time, we provide a judge and a lawyer to that person.
That is correct, and that's something we've been working on together for 5 years. And just to respond, if I may, because I think this is a very good discussion, do you agree with me, Senator Levin, that the law that exists today in terms of the Supreme Court's rulings, that an American citizen can be held as an enemy combatant?
I read this twice yesterday. I want to read it again now, and you are exactly right. This is a line, and Senator McCain just read it. And I don't know how anyone reading this can reach any other conclusion but what the Supreme Court says, not because they're right or wrong, but because of the Supreme Court. Quote, there is no bar to this nation's holding one of its own citizens as an enemy combatant.
Well,
And by
Senator,
the way, nor should there be, in my judgment, but that's not...
Senator Levin, do you agree with me that in past wars, American citizens, unfortunately, have collaborated with the enemy?
They have, and they have been treated as enemy combatants when they have done
Do you agree with me that in World War II, some American citizens decided to assist the Nazis and they were held as enemy combatants?
I do agree with
Do
you.
you agree with me that it's good policy to interrogate someone who is helping al-Qaeda to find out what they know about the enemy?
It's good policy, and if the administration decides under the procedures which are in their hands, under our language, that the person should be first interrogated for whatever length of time those procedures provide by the FBI, by local police, or anyone else, they've got the right to do that under our language.
Do you agree with me that the criminal justice system is not set up to gather military intelligence?
I think that's true.
Do you agree?
Could I ask the senator
Yeah.
from South Carolina, I don't mean to interrupt, but under the senator from Illinois' interpretation of the Constitution of the United States, if it's an American citizen, say over in somewhere in Pakistan, that is plotting and seeking to kill or destroy American citizens, it's okay for us to send a predator and fire and kill that person. But according to Senator from Illinois' interpretation, if that person were apprehended in Charleston planning to blow up Shaw Air Force Base, then that person would be given that individual's Miranda rights. Now, how in the world does that fit? I mean, it's, again, this is one of the more bizarre discussions I've had.
The senator will yield.
In 20-some years I've been a member of this body. Go ahead.
It would be the law as it exists today is an American citizen can be held as an enemy combatant. The question we're debating on the floor of the United States Senate with my good friend Senator Feinstein, she is saying that in the future, an American citizen who is deemed to have collaborated with al-Qaeda, the Taliban, or affiliated groups can no longer be held as an enemy combatant for an indefinite period, which means that you can't hold these people and gather military intelligence about what they know about past, present, and future attacks. And I would argue that we would be the first Congress in history to bring about that result, and I would argue that to do it now would be the worst time in American history to take that option off the table, because if you can't hold an American citizen who is suspected of assisting al-Qaeda under the law of war, then the only other option is to put him in the criminal justice system. And in the criminal justice system, you cannot hold someone indefinitely. You cannot ask them about future attacks or past attacks because you're investigating a crime, nor should you be allowed to do that under criminal law. The point I'm trying to make is that when you assist the enemy, whether at home or abroad, you've committed an act of war against your fellow citizens, and the Supreme Court acknowledges that the executive branch has the power to hold you as an enemy combatant. The question for the United States Senate, are we going to change that to say in the 21st century, 2011, every American citizen who chooses to cooperate with al-Qaeda no longer can be interrogated for intelligence gathering purposes by our Department of Defense and our intelligence community? They have to go in the criminal justice system right off the bat where they're given a lawyer and read their Miranda rights. If we do that, we're going to deny ourselves valuable intelligence, and we would be saying to our fellow citizens that we no longer treat helping al-Qaeda as an act of war against the rest of us. And I would argue that if you suggested in World War II that someone who collaborated with the Nazis should be viewed just as a common criminal, most Americans would say no. The day you chose to take up the Nazi cause, you turned on your fellow citizens, and you're now part of the enemy. That's all I want to do, is keep the law as it is, because we need it now more than ever. I am very sensitive to due process. There's more due process in this war. Every enemy combatant at Guantanamo Bay captured in the United States has to go before a federal judge. The military has to prove their case to a federal judge. Unlike any other war, there's an annual review process. That all makes sense to me. But what doesn't make sense to me is for this country and this Senate to overturn executive power that makes eminent sense at a time when we need it the most. It doesn't make sense to me to set aside a Supreme Court case that acknowledges that when an American citizen affiliates with al-Qaeda, that is an act of war against the rest of us and criminalize that conduct, denying us the ability to gather intelligence. If we go down that road, we have weakened ourselves as a people without any higher purpose. And to those American citizens thinking about helping al-Qaeda, please know what will come your way. Death, detention, prosecution. If you're thinking about plotting with the enemy inside our country to do the rest of us harm, please understand what is coming your way. The full force of the law, and the law I'm talking about is the law of armed conflict. You subject yourself to being held as an enemy of the people of the United States, interrogated about what you know and why you did what you were planning to do, and you subject yourself to imprisonment and death. And the reason you subject yourself to that regime is because your decision to turn on the rest of us and help a group of people who will destroy our way of life is not something we idly accept. It is not a common everyday crime. It is a decision by you to commit an act of aggression against the rest of us. I hope and pray that this Senate will not, for the first time in American history, deny our ability to interrogate and find intelligence from those citizens who choose to associate with the enemy on our soil. Because if we do that, it will be a deviation from the law that's existed at a time when we need that law the most.
Will the gentleman yield?
I'll yield.
I thank the gentleman, and I'm going to yield to Senator Feinstein in a minute, but I will just say I very much appreciate this debate with my friends and mentors, the three of us who were just debating, all military officers, but we have different views. We are dangerously close to being like the House of Representatives right now, where we actually have a face-to-face debate, and I appreciate that. I would say, though, that the law that should not be changed is the Constitution of the United States, that we realize that the regulations of the U.S. have force, that the statutes of the U.S. have greater force, that the Supreme Court decisions have even greater force, but no document is above the actual words of the Constitution. And I will say those words are your birthright as an American citizen. The Sixth Amendment says that you shall be secure in your person, and that shall not be violated, quote, and no warrant shall issue except upon probable cause, meaning that a court has made that decision. That your Fifth Amendment rights say that no person, there is not exception in the Constitution, shall be held to answer for capital or otherwise infamous crime unless presentment or indictment of a grand jury. And by the way, I'm talking very specifically about a United States person inside the jurisdiction of the United States. That your Sixth Amendment right says in all criminal prosecutions the accused shall enjoy the right of a speedy and public trial. And of course, your 14th Amendment right, saying no state shall make or enforce any law which shall abridge privileges or immunities of the citizens of the United States. These are without question for United States citizens. Part of this is a balancing act between the threats that we perceive. We know the threats from foreign enemies and terrorists. That's well known to us, and especially the new generation of Americans that witnessed the mass murder of September 11th. But the Founding Fathers were also wrestling with another threat, the threat of the state, the government itself against its own individuals, and the abuse of power. And we would forget the lesson of history unless we also understood that that is a threat as well. That we are told that there will be no intelligence benefit if a U.S. citizen is arrested and interrogated by Homeland Defense or FBI people. And yet, I would say, as a member of the intelligence community, the FBI and the Department of Homeland Security are part of the intelligence community and feed information into the intelligence community and can be used. One of the key ideas behind our American government, it's not what we do, it's how we do it. And one of the things missing in Section 1031 is who is the decider. The decider in this case is on suspicion of being part of al-Qaeda, the Taliban, or committing that belligerent act. that we have no court making the decision, that you as an American no longer have a right to the civilian court system, and those rights are inherent to you as your birthright as an American citizen, that what we should make sure that we do here now is that we understand that your rights as an American citizen to be incarcerated are only on indictment by a grand jury, which is preponderance of the evidence, and then conviction beyond the shadow of a doubt, unless, under this language, you are accused of being part of Taliban, al-Qaeda, or committing an act. And then you can be held subject to only one habeas review on preponderance of the evidence. Now, most Americans think that you can only be convicted of a crime in the United States beyond the shadow of a doubt by a jury of your peers. But if this is passed, that is no longer true. We want to make sure that the decider always is a civilian Article III court, that we are talking about a very, very specific definition here, inside the jurisdiction of the United States, among American citizens. That I agree that we can kill Anwar al-Awlaki, who is making war on the United States from a foreign jurisdiction. But when we are inside the United States, the whole point of the U.S. military and our establishment is to defend our rights, and those rights cannot be taken away from us by any executive action. They can only be taken away from us by action of a civilian court, by a jury of our peers, and by their decision beyond a shadow of a doubt. And with that, let me hand it over to Senator from California, whose amendment I so strongly support, and yield the floor to her.